There are a handful of formalities behind launching your successful corporation. From the certificates and the permits you need to acquire to the operational agreements you should put in place. There are formal documents and contracts that are critical to the foundation of your business. I'm Andy Contiguglia. I am the owner and the founder of the Contiguglia Law Firm here in Denver, Colorado. We deliver ambitious, creative legal and business solutions for the never complacent company so you can feel confident that your company is protected. So if you're a business leader or an influencer that wants to ensure that you're launching your business on the right foot, I encourage you to subscribe to this channel and to keep yourself informed of the legalities about what you need to do to be recognized as a legal and lawful business. All right, so let's sit down for some coffee, bagels, and legal to talk about the 5 documents you need to start your corporation. All right, let's get down to business. Now, in this video, I'm specifically going to be discussing the documents you need if you are launching a corporation. If you're still trying to figure out how you should structure your business, whether it should be an LLC, sole proprietorship, S-Corp, that kind of thing, well, watch my video here on how starting a business works. All right, so let's jump into this. The first step in launching your corporation is acquiring a certificate of incorporation. You can't become a corporation without it. Now, this certificate is the primary governance document for your business. Once it's issued, it can't be changed without stockholder consent. So the first thing you have to do it straight out of the gate so you can avoid the headaches down the road. Check with a local attorney in your state for the filing requirements that are specific to your area. And depending on your state, you might have to consider additional provisions such as a little thing called indemnification of directors and officers. Either way, the more classes of stock the corporation has, or if it's a public company, the longer and more complicated this document is going to be. With that being said, bring in your lawyer at this point. Really pretty good idea. Now, second to the certificate of incorporation comes the bylaws. The bylaws typically include the blueprint for how things are going to be done within the corporation. So take, for example, how to hold the procedures for meetings, whether it's for stockholders, directors, officers, committees, those types of individuals for the corporation. These bylaws set forth the operational guardrails on things like how voting on key decisions will work and how the issuance and transfer of stock certificates is going to happen. Now, as I mentioned, this document comes second to the certificate of incorporation. If there are ever any conflicts between the bylaws and the certificate of incorporation, the certificate will take precedent. To put it simply, both of these documents are necessary to help keep the legal structure and the integrity of the governance process of a corporation in place. After these 2 documents are put in place, you are going to have your organizational meeting of the board of directors. So either the incorporator or these initial directors, if named in the certificate, these people need to take immediate action to keep the ball rolling. Right? They need to adopt the bylaws. They need to appoint directors. They need to transact other limited business that is authorized under state law. The true action begins once the directors are appointed. Now, it's customary to hold an initial meeting with all of these directors as soon as they are appointed to align on electing officers, opening bank accounts, issuing stock, and approving the corporate seal. Now, we call this the organizational action of the incorporator and the first meeting of the board of directors. Again, check with a lawyer who is familiar with this in your state and check your state corporation laws for the specifics of what needs to be done. Some states allow corporations to appoint the board of directors in the certificate of incorporation, while other states require the passing of organizational minutes of the board in order to authorize this first action of the corporation. Whatever is required in your state, it's critical to ensure that you go about a legal structure and structuring your organization in the right way and with the right documents in order to roll things out in the right order. Now for the fun part. This is issuing of stock. The corporation issues stock to its stockholders after or during the first meeting. It can also happen with a unanimous written consent of the board of directors. Typically, each stockholder enters into what we refer to as a subscription agreement that defines the terms of the issuance of the stock. You should also consider issuing stock certificates to these shareholders. If it becomes a part of your common practice to deliver stock certificates to each shareholder, then make sure it's signed in original and by 2 officers, typically the president and the secretary. Finally, don't forget to record all the issuances of stock in the stock ledger. Now, obviously, there are a lot of federal and state securities laws to govern how corporations can issue stock, and that's really beyond the scope of this video. Generally, however, if there are only a few stockholders, The issuance typically qualifies for an exemption to registration under the federal securities laws. However, if the stock is being widely offered, your attorney must determine if the stockholders are accredited investors or fit within other exemptions to the security laws. The issuance of stock is also regulated at the state level by each state's security laws, and we commonly refer to these as blue sky laws. It's important that your counsel reviews the security statutes and regulations of each state in which the stock will be offered or sold. Anywhere from New York to California, each of these states will have its own filing requirements, and each of these requirements must be met. And it's on you to ensure that you are compliant. Because what happens if you fail to follow these federal and state securities laws? It can lead to criminal prosecution and hefty fines. So make sure you speak with an attorney who's familiar with the various securities laws applicable to your situation. Stockholder agreements are not absolutely necessarily required when you're getting your corporation off the ground, but they are smart to put in place. These agreements are used to set forth certain rights and obligations such as voting, transfer restrictions, registration rights. These may be addressed in one or more stockholder agreements or in several shorter agreements. You can think of the stockholder agreement somewhat as a prenup between the various shareholders of your company. Now, you're not going to want to skip this one. The stockholder agreement provides the greatest amount of protection not only to the corporation, but also to the other shareholders of the corporation. And how you formulate your shareholder agreement really will dictate how you can sell or dispose of your stock in a corporation down the line, or if some of the shareholders want to leave. It sets the precedent for how this important element of your corporation will run as you scale your business to success. Organizing your corporation shouldn't be rushed. Take the time to really think about the structure you want and how certain events should take place over time. There are many boilerplate agreements out there, and you can find many on the internet, and while they do provide the proverbial trick, they might also create more problems down the line, and we want to avoid that. The key here is to consult with a lawyer who will really be able to understand the direction that you want to take with your business and help you craft a solution that will take your goals and your objectives into consideration. So take the time to strategize and look to the future, because if you run into any problems, they won't be here today, they will be several tomorrows down the line. Please remember, my goal on this channel is to share content that will guide you in making sound business decisions and keeping your brand operations and overarching business protected for years to come down the line. So if these tips were helpful to you, please like this video again and click the subscribe button below. Feel free also to drop any specific topics that you'd like to know more about in the comments. I'll see what I can do to incorporate some of your questions into my next video. As always, if you have any specific legal questions on how to structure your business, how to run your business, feel free to reach out to me directly. I'm always happy to answer any questions that you have as you launch and scale your business. I'm Andy Contiguglia, and until next time, remember, don't skip the legal.